she didn't want mom, Lyric didn't want mom to call the police again. So Lyric would have to leave dad's house and go home.
Where would she get the idea that a police officer can come get her and take her away from her dad?
Because that one time that we went, well, that I had to call the cops to get her back. I don't know why and where, but she tells me pretty frequently that she loves her dad, but she doesn't like staying the night there.
Her next friend, Henry Matlock, and Jordan Martin. Case number 2022 DM 216. Patrick Blanchard appears as counsel for Henry Matlock. Mr. Matlock appears in the office of his lawyer. Jordan Martin appears apparently still representing herself. This matter comes before the court at this time for review of case status. Back on March the 7th, this court had a non-evidentiary hearing. The court ruled that the motion to modify the parenting plan stated a prima facie case. The court granted as a temporary order a parenting plan with every other weekend visitation, Wednesday night start, and the court set a review hearing today. That was eventually journalized, I believe, by Mr. Blanchard. Court also notes that there is a motion currently before the court that was filed back on May the 1st, where there was a request for this court to appoint a guardian ad litem or a domestic conciliator. Mr. Blanchard, what is the current status of this matter?
Yes, Your Honor. Can you hear me?
I can.
Okay. Yes. It is set for review today, Your Honor, and it also is set for the motion that we filed because we believe an independent third party who's a professional could provide the court with needed information and perhaps avoid the necessity for a trial. I would tell the court that all the concerns we had that were filed in our verified motion are largely still present in this matter. The expanded visitation that the court ordered that we started getting after the hearing on March 7th has gone reasonably well in terms of the child, my client having more access with the child. There was one, I just call it a hiccup, when my client was out in Western Kansas coming in and called Miss Martin and said he'd be just a little bit late picking up. Would his father pick up? And she didn't want to do that initially, but eventually my client's father did pick the child up. My client was going to be 15 or 20 minutes late. So that went through all right. There have been concerns about how the child is when my client picks the child up. My client reports, and his wife or fiance also reports, that the child often comes not bathed, with her hair matted, and not appropriately clothed. And especially one day when it was about 50 degrees out, she was not appropriately clothed at all. My client did say that the child is happy, comfortable, enjoys being with him and with his fiance and with his other family members. They're all closely bonded with each other. The child has opened up to him more and more with the expanded time that he's had, which is very comforting to my client, very encouraging to him. He is very, very concerned about the arrangement that she comes from. We still believe there was one occasion when my client and his fiance picked up the child, Lyric, in April 20th, I believe it was, and Miss Martin.
Counsel claims the mother smelled of marijuana during exchanges and requests hair follicle testing, even offering to pay. Drug tests can affect emergency motions, but courts require strong evidence. This allegation raises child safety flags. But remember, allegation proof without verification.
Martin did have a significant odor of marijuana on her person, which caused my client concern, which caused me to then file the motion after I was given that information, filed me a motion to have an independent third party do an investigation. It is an issue. We thought we adequately prepared it for the court and provided exhibits at the last hearing on March 7th. I respect the fact that the court did deny that motion. We're kind of renewing this motion again. At that time, we did offer that we would pay for the test of the cost of a hair follicle drug test, and that my client would also submit to a hair follicle drug test and pay for both. And we are renewing that motion, that part of the motion today on the review hearing. I would say that my client has had another child since that time, and Lyric seems to be very comfortable and happy to have another sibling in the house. That my clients have, my client, Mr. Matlock does have appropriate housing. The child has her own room in his house. As we reported the last time, Lyric, the child, sleeps in the same bed in the same room where Miss Martin resides. There are 6 people, 5 adults and Lyric in that house. It has one bathroom. It's a very crowded place for the child, and we don't believe that is the best situation for the child to be in at that time, at any time. But, we think that situation should be corrected in some way. And we think more time with my client would make that a better situation. I would tell the court that my client did send an email or a text message to Ms. Martin to see if they could discuss it on their own and arrive at him having some expanded parenting time. Her response, according to my client, is she said, "No, I think things are going well the way they are. So I'm not wanting to expand your time with Lyric." And so they never sat down and talked about it, which I think would have been a good idea if both parties went in with an open mind. And I understand Ms. Martin's position is that she doesn't want to give up any more time than she has to with the child. But still, I think part of the thing about a review hearing and for the court to determine how things have been going, that the parties to discuss and try to work out an arrangement on their own would be the preferred way to do that. If we have a guardian ad litem and or a domestic conciliator, they could go through the mediation process, and then if that doesn't work, then an investigation can be done, and the court would then have an independent third party who could report what that person thought, who's a professional, was in the child's best interest. So those are the things that are a great concern to us. I would tell you that, and this happened just yesterday morning when Lyric was in my client's home, and Lyric, according to my client and his fiance, said that she didn't want Lyric didn't want mom to call the police again, so Lyric would have to leave dad's house and go home, which suggests to my client, and that happened once before, and that was one of the things that spurred on the motion that we filed back and heard on March 7th. It certainly would seem that Miss Jordan is probably discussing things with Lyric that are.
The child reportedly asked police to remove her from dad's home and says she cries at night. That's explosive. Courts will probe how suggestion, context, and age affect these statements in court before assigning weight to a toddler's words.
Not in her best interest. What we would propose, Your Honor, in the interim, if the court would appoint a guardian ad litem or a domestic conciliator, is that we would expand my client's parenting time to every other weekend that he has the child overnight on Sunday to Monday mornings, and he has every Wednesday night until 7:30, and we would like that expanded overnight to Thursday morning. We think this would ease the transition even more, pending the report if the court orders it. And we also would say if the court would grant our motion to have hair follicle drug test by both parties, that if either party tested positive for an illegal drug, that we could file an emergency motion for the court to consider that issue. So those are the things before the court today. And again, we're renewing the motion for the hair follicle drug test.
All right, the current parenting plan is Henry having the child every other weekend from Friday at 6 to Sunday at 6.
Yes,
And
Your
then
Honor.
every Wednesday for 2.5 hours, correct?
That is correct. And then there is a specific holiday parenting plan as well in place.
All right. All right, Ms. Martin, you've patiently waited for Mr. Blanchard to make his opening statement here. Do you have any response to what's being proposed?
There was a lot said, but I do have a comment on the fact of the police officer. The whole incident, I'm not disclosing or talking to my 3-year-old about things that she should have no clue about or is going to be confused about. She has all of a sudden, randomly, she's been coming to me on the last day that she just dropped off, and later at night, she tells me she loves me and all this and that. And then she tells me that she wants me to call the police officer to have the police officer come get her because she doesn't want to be at her dad's at night. She wants to sleep with me. But I tell her that we can't do that, and that's you have to be with your dad, and your dad wants to spend time with you on the weekends. And I'm not doing anything wrong. I'm not discussing or disclosing anything with her that I should not be, or that's above her age level.
Where would she get the idea that a police officer can come get her and take her away from her dad?
Because that one time that we went, well, that I had to call the cops to get her back. I don't know why and where, but she tells me pretty frequently that she loves her dad, but she doesn't like staying the night there. She tells me, I cry for you all night, Mom. I tell her, I'm sorry. There's nothing I can do.
All right.
May I respond to those comments, Your Honor?
You may.
Yeah, thank you. The whole thing was started because she called the police because there wasn't any specific parenting plan in place at the time, and she did call it for a welfare check. And then the police officer did say that there was nothing wrong, but he said let the mother have the child for a moment, and then the mother would not, Ms. Martin would not let the child come back to my client, even though they had been following a de facto schedule. There was nothing in a written order as to what a specific parenting time was. And the officer said, I'm sorry, this is a civil matter. If you don't have it on paper that you have this specific time, there's nothing I can do about it. That's what it is. And it was an inappropriate call from our position with regard to the time that she called the police and was out of anger on Miss Martin's part because she wanted the child back and it wasn't her time to go back under the de facto plan. One thing that's just telling by her comments about the child, and my client would say the child does not cry overnight when she spends Friday night overnight and Saturday night overnight, that the child is very comfortable and happy there. So he doesn't know what that's about, but we have people there that could testify that that is not the issue when the child is there. And the people would testify as to what I've already described to the court today as to how comfortable and happy the child is there. But the one telling thing that Ms. Martin said in her response to my opening argument was that the child wants to come back and sleep with me, which confirms that the child who is 3 years old going on 4, it continues to sleep in the same bed with her mother, which we think that is a concern for the development of a child over time. So with that said, Your Honor, we ask the court to rule on the arguments we made in the motion and the review hearing today.
All right. Before the court would consider the appointment of a guardian ad litem, the parties would have to commit to providing sufficient funds into, say, Mr. Blanchard's client trust account that would of at least $1,000. It would be very difficult for a guardian ad litem to do their job without at least that much time involved in investigation and report writing and the like. And even that is a very conservative amount. Could your client commit to the $500 necessary to deposit for that?
The judge favors appointing a guardian ad litem, a neutral attorney to investigate and recommend what's best for the child. This reduces parental spin and brings evidence, home visits, interviews, and documents. Cooperation with the GAL is crucial. Non-cooperation can hurt a parent's credibility.
That purpose, Mr. Blanchard?
Yes, Your Honor.
And I trust Ms. Martin, you could do the same?
No, I couldn't.
Are you working currently?
I am, but I'm trying to get out on my own.
Okay, well, all right.
Your Honor, my client would upfront $1,000, so Ms. Martin's portion would be paid, and reserve the issue about any reimbursement.
Understood, and I think that's a fine gesture on his part to do that, Mr. Blanchard. Who would you propose be appointed as guardian ad litem in this case? There's a couple of names in mind.
I don't remember her name. It's Sharon. I think you've used her before. Is it Sharon Leal? There's somebody in Butler County that I think does a very nice job. And her name
You're talking about Susan Locke?
Susan Locke. That's it. Yes, Your Honor. Or Josh Andrews. I've used Josh before too.
All right. Would be comfortable with the appointment of Susan Locke, but Mr. Blanchard, if you will check with Ms. Locke to make sure she's available to perform this task.
Okay. And if she's not, with an appointment of Josh Andrews, would that be appropriate with the court if Susan is not available?
It would be if he would commit to being available for this purpose.
Okay.
And hopefully you won't have to go to a third name, Mr. Blanchard.
Yeah.
Ms. Martin, the court's inclined to appoint a lawyer, essentially, to represent the interest of the child. called a guardian ad litem. And what they do is that they make recommendations in the best interest of the child. They're a neutral. They don't represent you. They don't represent Mr. Matlock. They represent the child's interests.
Okay.
So they would do an investigation. I would expect you to cooperate with whatever questions the guardian ad litem has. If they need documentation from you, whatever it might be, they may even come out and want to do an inspection of your premises. And the court would expect that you'll cooperate with that as well, if that is requested. And then this person would make an independent recommendation to the court as to what's in the best interest of your child, which the court would put some weight on. It may or may not be controlling, but the court would certainly consider the recommendations of this third-party attorney who's representing the interest of your child. And Susan Locke will be the first one to be approached, and then Josh Andrews after that. And you'll journalize this guardian ad litem order, Mr. Blanchard?
Yes, I will, Your Honor.
Mr. Matlock, the commitment's been made that you'll deposit $1,000 for this purpose in your attorney's client trust account. Mr. Blanchard, my policy is you don't disperse money out of that account without a specific order of authorization from this court.
Okay, yes, Your Honor, I understand that.
All right.
May I ask about the request to expand his parenting time and the with regard to overnight on Sundays on his alternating weekends and overnight on Wednesdays when he has the child during the week?
Ms. Martin, I don't know that you specifically addressed that. The request has been made to allow another overnight during the week and on the weekend. Your position?
I don't think that that's very wise at her age because she's going to be starting school soon. So I think that that's going to be a little hectic.
Okay, first of all, the traditional school year is about ready to end. We're going to get into the summer.
Yes.
And she is just ready to turn 4, so she won't be starting kindergarten.
No, but she's going to be in pre-K all day until I get off work.
Okay, and that would start what, in August sometime?
Yes.
All right.
The court permits expanded Wednesday overnights and Sunday to Monday carryover, easing transitions and increasing father's time. That signals the court values involvement and routine. Yet the judge again declines drug testing, meaning allegations didn't convert into enforceable proof today. Expect follow-up review hearings.
So if during the summer, if overnights on Wednesdays, I don't see why not.
And then what time would it be contemplated that the child would be returned to the mother on Wednesday, which would be essentially Thursday morning?
Thursday morning. We could do an exchange at what, 8 or 9 o'clock in the morning?
It'd have to be before 7. That's when I go to work. I could just,
Well, that's awfully early in the morning for a
You got
child.
a
in the
family
summer.
member, right?
I could possibly have a family member do it around
8.
7:30.
Okay. 7:30 or 8?
All right, by no later than 8 a.m. then on Thursday morning, the court will allow the expansion of parenting time on the Wednesdays. What about the Sunday night to Monday morning? Is that the same issue that he goes to work early on Monday?
Yeah, it's same. It's I start my shift at 7 Monday through Friday.
But we can have a family member drop her off no later than 8.
If I may speak, I start work a lot earlier than both those times. I go in at 6 a.m., sometimes 7 a.m.
Okay, so who provides care while you're working?
My mom, she babysits her for me, and I pay her bi-weekly.
At your house?
Yes.
We would
Okay,
make
well,
the
the drop off would be the same, whether it's to Jordan or to the mother. Okay, I don't see that the Sunday overnight to Monday interferes substantially with the mother's parenting rights. She gets up early and goes to work on Monday morning. Mr. Matlock, if you want to keep the child overnight on Sunday on your weekends, drop them off essentially to grandma at Jordan's house on Monday morning, I just don't see that that would be inconsistent with the best interest of the child at this point, and the court will allow that expansion as well. I just hope that everything's going well during your time with this 3-year-old.
And Your Honor, one last time, and I want to belabor the point, but with regard to the hair follicle drug test, has the court changed its mind at all from its initial order?
No.
All right, thank you.
Court still declines to order drug testing in this case.
Okay, I'll prepare the order as you have specified, Your Honor, and I'll submit it pursuant to Supreme Court Rule 170. With regard to the specific order, can I put that in, that will I have to contact you to disperse money to the guardian ad litem, or can I put that in the order that with the guardian ad litem's request, I'm authorized to disperse money to the guardian ad litem?
Yes, either the guardian ad litem can make the request to the court, or you can on the guardian ad litem's behalf. I just want to make sure that there is court-ordered authorization for any disbursements from that fund.
All right, I'll include that in the order, Your Honor. Thank you.
Please do, Mr. Blanchard. I want to set this case for a review hearing. I don't want to lose track of it. And I want to monitor progress. So what would the time frame that you would anticipate, Mr. Blanchard, to get this order done? Perhaps Ms. Locke on board, let her to do her work, and perhaps be in a position to be able to report back to the parties and the court.
I would think
60 days?
Yes, Your Honor, that would be fine.
All right.
So we'd be looking at sometime in July, is that correct, Your Honor?
Yes.
Your Honor, the week of July 14th, I'm not available, but I'm available the week after that, anytime on the 21st. I'm available.
Monday, July 21 at 11 o'clock a.m., counsel?
Yes, Your Honor, that's fine.
Court will conduct another Zoom review of the status of the case Monday, July 21, 11 o'clock a.m. Hopefully the court and the parties will have available a guardian ad litem report by that time. If not, we'll review progress and do further scheduling as may be necessary at that time.
Thank you.
I'll look forward to receiving your order of modification, Mr. Blanchard, and we'll review the case by Zoom Monday, July 21, 11 o'clock a.m.
Thank you, Your Honor.
All right.
Henry gains expanded parenting time and a guardian ad litem will investigate. Drug testing denied. The next review hearing will be decisive. If you're following this, tell us. Who had the stronger case? Like, comment your take, share and subscribe for more breakdowns.